Hi, everyone. Thank you for joining us today for Constangy's webinar, Managing Employee Leave under the FMLA and ADA. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. Before we begin, I'd like to mention a quick update regarding our presenters. Unfortunately, due to Hurricane Milton, Damon Kitchen is unable to join us today. However, we're grateful that Constangy partner Sarah Phaff has graciously stepped in to fill his place. Our thoughts are with all those affected by the recent hurricanes. I'm now going to turn it over to Elysia and Sarah to begin today's presentation.
Good morning, everyone. My name is Elysia Analo. I am Senior Counsel here at Constangy in our Chicago office. I will go ahead and kick us off here. I know that we have a limited amount of time today. But essentially, thank you all for joining us today. Sarah and I will be diving into two key laws that govern how we handle employee leave, the Family and Medical Leave Act and its intersection with the Americans with Disabilities Act. And, managing leave under these acts can be a challenge. So today we'll be focusing on practical strategies that go beyond the basics and help you manage your leave in a way that minimizes legal exposure while also keeping your business running smoothly. So before we start off, because leave is one of many accommodations under the ADA, we're going to start with a quick refresher of the FMLA, which focuses on leave specifically. So here we know that the FMLA provides up to 12 weeks of unpaid job-protected leave for employees with an extended time of 26 weeks for military caregivers. And the FMLA, it's not just a benefit, it's a right. So mishandling an FMLA request can open the door to claims of retaliation and interference. And these are two of the most common reasons employers find themselves in court, which we want to avoid. So retaliation occurs when an employee alleges that they were punished for taking or even just requesting FMLA leave. And then on the other hand, interference claims arise when the employer is accused of hindering or blocking an employee's ability to exercise their rights under the FMLA. But at the heart of both of these claims is just making sure your processes are responsive and consistent, which we will discuss in more detail today. And another really, really important note is that the FMLA does allow for individual liability. It's easy to forget that under the FMLA, unlike the ADA, managers and supervisors could be personally named in lawsuits. So FMLA compliance isn't just a company issue. It's a personal one for your leadership, for your team, and making sure that you're training people at every level in the company and not just HR on how to handle FMLA requests appropriately. So who's covered? Public sector, definitely covered. I think of what's more relevant for most of our guests today is what happens in the private sector. In the private sector, your company is covered if you employ 50 or more employees in 20 or more work weeks during the current or previous year. Now, this sounds very straightforward, but here's what often gets overlooked. So first, keep in mind that if your company employs more than 50 people overall, the FMLA may not apply to a specific work site if that work site has fewer than 50 employees within a 75-mile radius. Also, another area where employers can get hung up is with joint employer relationships. So if you use a staffing agency or you share employees with another business, you might be considered a joint employer. So this would expand the scope of your FMLA liability. So if you have contractors, again, temp employees, or if you're part of a franchise system, make sure you understand how those relationships impact your FMLA responsibilities and aggregating or counting the number of people that would make you liable or a covered employer under the FMLA. It can be a trap that a lot of employers fall into, and we don't want that to be you. And then who is covered here with the FMLA? Who qualifies for FMLA? Well, an employee needs to work for the company for at least 12 months, although these don't have to be consecutive, and they must have logged 1,250 hours in the 12 months preceding the leave request. And again, the employee need to work at that location where the employer has 50 or more employees within 75 miles. So here's where businesses often stumble, is kind of calculating that eligibility accurately. So sometimes an employee's time could be spread across several locations. Also, more recently, in our post-COVID world, is the issue of remote workers. So DLA guidance has said that when an employee works from home or otherwise teleworks, their work site for FMLA eligibility purposes is the office to which they report or from which they receive their assignment. So if, for example, your company is based in Chicago, you have one remote employee that's in Montana who gets all of her assignments and work from her manager in Chicago, then for FMLA eligibility determination, her work site could be Chicago. Also, keep in mind that when employees don't qualify for leave under the FMLA for whatever reason, they may still be eligible for leave under the ADA, especially if that leave is related to a medical condition that qualifies as a disability. So the key here is to never assume that somebody is simply ineligible for leave without a thorough review of the circumstances for that employee and their leave request. Now I'll pass along to Sarah.
Thank you so much, Elysia. And good morning, everyone. As mentioned, my name is Sarah Phaff. I'm a partner in our Atlanta office. Looking forward to covering the FMLA and ADA topics with you today. So we'll go ahead and dive in to under what circumstances can FMLA leave be taken. So as initially enacted, FMLA leave could only be taken for the following 4 reasons that are up on the screen: the birth of a child and to care for the newborn, the placement of a child with the employee for adoption or foster care, the employee is needed to care for a child, parent, or spouse with a serious health condition, or the employee's own serious health condition when the employee is unable to perform the essential functions of his or her job due to that serious health condition. You'll note that all of these 4 reasons provide an employee with 12 weeks of job-protected FMLA leave that can be taken during a 12-month period. And I know you see a lot of terms there that you probably have questions about. Don't worry, we're going to define those for you a little bit later. I wanted to give a couple of examples here just so that we take this out of the theoretical and into the tangible. So, for example, an employee who is not married to their partner but will co-parent their partner's child may take leave for the birth of the child and for bonding with the child, even if they're not the biological parent of the child. And again, we're going to unpack some of these. An employee who has an ongoing responsibility for raising a grandchild may take FMLA leave to care for the child when the child has a serious health condition. So these are just a couple of examples of, I'd say, more unusual situations where FMLA leave is used. So you heard me say here that this is as initially enacted. So as you can expect, there were some changes. And our next slide shows those. In 2009, the FMLA was amended to add 2 additional reasons for taking leave: the any qualifying exigency arising out of the fact that the employee's spouse, child, or parent is a covered military member on active duty or has been notified of an impending call or order to active duty in support of a contingency operation, or to care for a covered service member with a serious injury or illness if the employee is the spouse, parent, child, or next of kin of the service member. We refer to this as military caregiver leave. That's probably how you have heard it referred to as well. And so we wanted to, we'll use that shorthand for today's webinar. So these, additional amendments were made, and there is a difference in how we do the documentation and tracking for these types of leave. So I'm going to put a pin there as a note for our folks. As you're dealing with the various types of leave under the FMLA, there are some differences for these 2 types of leave as opposed to the other 4 that we were discussing on the previous slide. As we'll note throughout today, again, the ADA might also require that an employee is provided leave through the ADA as well. So simply that an employee may or may not qualify for leave under the FMLA doesn't end your analysis. This might be particularly relevant if the employee is, for example, dealing with PTSD or other service-related conditions that may qualify as a medical disability. Then that employee may also be entitled to leave under the ADA. So just remember that these analyses are sort of intertwined. And we're going to discuss a little bit more what a qualifying exigency is and define some of these terms that we've talked about in our overarching umbrella. So let's dive into defining our terms under the FMLA. So we're going to start with the first set of terms, spouse. A spouse is a husband or wife who are married to each other in accordance with the laws of the state in which the employee resides. So there, that starts our definition of spouse. This would include individuals in common law marriage and individuals who are married same-sex couples. A spouse would also include a husband or wife in a marriage that was validly entered into outside of the United States if the marriage could have been entered into in at least one state in the U.S. So again, these are all types of spouses as defined under the statute. Individuals in civil unions and domestic partnerships are not necessarily considered spouses under the FMLA, and so wouldn't share protections under the FMLA for the purposes of leave. The next is son or daughter, and you'll see that this is a broader definition as well. A biological, adopted, or foster child, a stepchild, a legal ward, or a person, or a child of a person standing in loco parentis, who is either under the age of 18 or over the age of 18, but incapable of self-care. So, we wanted to kind of flag this for you because a lot of folks don't think of son or daughter as potentially including folks who are over the age of 18. Again, that this is if the individual is 18 years of age or older and incapable of self-care because of a mental or physical disability at the time that FMLA leave is supposed to commence, then they may be a defined son or daughter under the leave. So again, they've got to have a disability as defined under the ADA, being capable of self-care, have a serious health condition, and need care because of that serious health condition. So that's another category where son or daughter might be a bit more expanded than you might think in the normal course. The next is parents, a biological, adoptive, step, or foster father or mother, or any person who stood in loco parentis to the employee when the employee was a child. This term does not include parents-in-law. We get that question a lot, so I wanted to go ahead and answer that one for you all up front, because a lot of folks ask whether or not it includes in-laws. In loco parentis, just to give you all a little bit more of a description about that, means that it's an individual who really stands what they call in loco parentis to a child if they have day-to-day responsibilities to care for or financially support the child. They are not, a person standing in loco parentis is not required to have a biological or legal relationship with the child. So, I just wanted to mention that as well. All right, we're going to move on to our next definition, which is next of kin of a covered service member. So generally, next of kin is going to be defined as you would think, spouse, parent, son, or daughter. Because generally to take military caregiver leave, right, as you probably saw on that earlier slide, but just to refresh your memory, to take military caregiver leave, the eligible employee must be the spouse, parent, son, or daughter, or next of kin of the covered service member. So what we're defining is, what do we mean by next of kin? For purposes of military caregiver leave, a son or daughter refers to the service member's, son or daughter of any age. And the next of kin can mean their nearest blood relative. So that could be one designated blood relative in writing or all blood relatives with legal custody. Following that, it could mean brothers and sisters, grandparents, aunts and uncles, and first cousins. And this is sort of the, quote, order of priority that's given to how to define next of kin under the FMLA. All right, we're going to move on to another definition here, serious health condition. Serious health condition is an injury or illness, impairment, or physical or mental condition that involves inpatient care, i.e. an overnight stay in a hospital, hospice, or residential care facility, or continuing treatment by a healthcare provider. This is a serious health condition, and we're going to go over what is involved in continuing treatment. But, we wanted to kind of differentiate for you that a serious health condition is one that makes the employee unable to perform the essential functions of their job. So there's, we're going to differentiate a little bit here between minor ailments. So for example, a cold versus a serious condition like chronic asthma. So there are going to be some differences here as to what qualifies as a serious health condition. So some examples may be an employee who takes leave for migraine headaches, for example, or an employee who takes leave for an ongoing chronic illness that requires treatment by a medical provider from time to time. Another example might be an employee who is having a surgery, for example, a gastric bypass surgery. That could be another serious health condition. So these are all some examples of serious health conditions. All right, so we're going to kind of define for you what a serious health condition involving continuing treatment by a healthcare provider includes. And you'll see up on the slide, we've got 1, 2, 3, 4, and 5, examples of what this would include, right? Incapacity due to pregnancy and prenatal care, a period of incapacity of more than 3 consecutive absences of full calendar days receiving treatment, incapacity due to long-term conditions requiring multiple treatments. So if an eligible employee requests FMLA leave, for example, we'd want to evaluate all of these things in terms of their eligibility. And so we just want to consider also the tie-in with the ADA. Again, for example, if an employee has a chronic condition, they may be entitled not only to FMLA leave, but they may be entitled to leave or other accommodations under the ADA. You may have 2 things happening at once. So employers need to consider that as well. And understanding how each of the statutes, whether it's the ADA or the FMLA, and how they apply, will enable employers to do a thorough job in ensuring compliance and ensuring that they're not missing an opportunity to provide an employee the leave or accommodation to which they're entitled. All right, we're going to move on to our next definition. I mentioned earlier we'd be defining a little bit more about a qualifying exigency. Okay, so qualifying exigencies, you'll remember that this relates to the military leave we talked about for the 2009 amendments, are situations caused by military deployment of an employee's spouse, child, or parent to a foreign country. So an employee may take FMLA leave for qualifying exigencies, including making alternative child care arrangements for a child of the military member when the deployment of the military member requires a change in the existing child care arrangement. For example, they might also be attending certain military ceremonies and briefing, taking leave to spend time with the military member on rest and recuperation. So these are just a few examples, and we're going to dive into these a little bit more, but wanted to give you sort of the overarching context. So here's a sort of specific practical example. Lucero takes FMLA leave to enroll his granddaughter in his school district during his son's deployment to a foreign country for a year. Lucero will also take FMLA leave when his son visits during the 2 weeks of his rest and recuperation leave. And I know I've said a lot there, so we're going to define what, some of these qualifying exigencies are that may allow an employee to take FMLA leave for those reasons, right? So we've got our list in front of us. So one of them might be short notice deployment, which is leave for up to 7 days beginning on the date the covered service member is called to active duty. Military events and related activities, childcare and school activities. So that's very similar to the example that I just gave you a moment ago. Financial and legal arrangements, leave taken to address financial and legal matters while the covered service member is on an active duty status. Counseling, so leave taken to attend counseling for the employee, the covered service member, and so on. Rest and recuperation, which will be on our next slide. Up to 5 days of leave during the service member's assignment for a period of R&R during deployment, post-deployment activities. And of course, there are additional activities, right? So there are other ways. They may be things that the employer and the employee agree to, or other things that are covered by the FMLA. This is obviously not an perfectly exhaustive list of everything that might fall into the categories, but We wanted to give you the overarching ones. And I'm going to turn it back over to Elysia to talk about how FMLA leave is to be used now that you've got a framework for what it means.
Thank you, Sarah. And I did see a comment from someone who was a public sector employer, and just to clarify, I didn't mean to gloss over that, but the FMLA does apply to public employers regardless of the size. So if you are a public agency, and that includes state and local government employers, you're covered by the FMLA. But moving along, here, the FMLA leave comes with flexibility, allowing employees to take it in 3 different ways that can present unique challenges for each one. So the first is the continuous leave. That's your traditional 12 weeks at once. This is usually typically straightforward to track, but it can still present some challenges when it's paired with an ADA modification or related modification. For example, when an employee returns on a reduced schedule due to a disability, you might have to coordinate that transition carefully to comply with the ADA requirements. So overlooking this can lead to an ADA-related claim. So it's kind of crucial that you have a plan in place for managing that return when someone does take the full continuous 12 weeks at once. The second kind of leave that an employee can take under the FMLA is the reduced schedule leave. And that's where an employee may work fewer hours or days off while on leave. And finally, there's the intermittent leave, which allows employees to take time off in blocks, perhaps for medical treatments or flare-ups of a condition. So here, the reduced schedule and the intermittent leave can really create some logistical hurdles. Here, employees may work fewer hours per day or take leave in blocks of time, which just makes it just logistically harder to track and to plan for. And these leave types can also really complicate things when you're dealing with performance management. So especially if an employee's role is very critical to daily operations, them not being there, them having that more flexible schedule can make it more difficult to kind of measure and track performance and make sure that you're not penalizing them for things that are related to their job protected leave. And their communication, planning, and flexibility are just key. You need to just think beyond tracking time. How will the reduced or the intermittent leave impact their workload? How can you ensure performance remains consistent without stepping into retaliation territory? And then just one more really quick important catch. Leave taken for birth or placement of a child must be continuous unless the employer agrees to the intermittent or reduced leave. So employers, you have some discretion there, so you can try and structure the agreement you have with the employee in a way that works for both the business and the employee. And so with reduced schedules, employees can take a reduced schedule or intermittent leave when medically necessary due to their own serious health condition or to care for a covered family member or the injury or illness of a covered service member. Another scenario is taking leave intermittently for a qualifying exigency, like the family member's military deployment. So what does medically necessary mean in practice? It means that the employee's health situation requires flexibility, and this is often where businesses run into complications. So it's really important to collaborate closely with your employees during this process. And this is where your good communication and strong documentation will make all the difference. Oh, and I'm sorry, I can go back, thank you. I should have also mentioned there that it's also worth noting that the ADA doesn't specify any particular leave structure, but it does require that leave be provided in a way that accommodates the employee's disability. So in some cases, that might mean a combination of intermittent FMLA leave and flexible work hours under the ADA. This is where things can overlap and get very messy. Managing that interaction between the two laws becomes very critical. And understanding how those laws work together can help you avoid pitfalls and making sure you're providing the necessary accommodations to your employees. So how do we track FMLA usage? So tracking continuous FMLA leave is relatively simple. You just track the weeks the employee is out. But for the intermittent and the reduced schedule leave, that's where it gets more challenging. So employers must track the time taken in increments no greater than the shortest increment used for any other type of leave, and it can't exceed 1 hour. So for example, that means if you account for your vacation or your sick leave in 15-minute increments, you need to use that same for the intermittent FMLA. And you generally can't reduce an employee's FMLA entitlement by more than the time that they've actually taken, except in rare cases like when it's impossible to start or end a shift midway. In those cases, you can treat the entire shift as FMLA leave. Again, that's a very tricky situation. I would encourage you to consult an attorney in that situation, but just wanted to point that out. And this is an area where it's really critical to have precise record keeping practices and clear policies in place. We really cannot stress that enough. Many employers will fall into the trap of not being meticulous enough with their tracking, which can lead to misuse or misunderstandings down the line. And as an aside, the ADA does not have these strict increment requirements, which can lead to inconsistencies if not managed correctly. But as I just mentioned, in some situations where an employee is unable to begin or end work midway through a shift, you can count the entire shift as FMLA leave. This exception usually applies in roles where there's no natural break in the workflow. Again, think healthcare providers or production line workers. This is a really important distinction. Again, this is a situation where I would very strongly encourage you to consult an attorney because it's not one that you want to overuse. If you over apply this rule, you could face claims of improperly reducing someone's time in an interference claim. So you don't want to improperly reduce someone's FMLA entitlement, which could, in turn lead to liability for an FMLA interference claim. So let's switch gears a bit and discuss employee notification requirements. So for foreseeable leave, employees are required to provide 30 days notice. And if that's not possible, they're supposed to give notice as soon as practicable. Generally, that's 1 to 2 business days, but again, it would depend on the circumstances and what happens with the employees. To protect your business, remember that employees are always required to follow your usual and customary practices for requesting leave. So if you have a policy that says requests must be made in writing or through a specific system, you can't enforce that. Another key point is just collaboration. Employees, they need to make sure they make reasonable efforts to schedule treatments and to avoid disrupting your operations. If that doesn't happen, you can document it. And then FMLA leave can be denied due to a lack of notice. But I wanted to have a little bit of caution here because the ADA may still require granting the leave as a reasonable accommodation, even if the employee failed to follow the FMLA notice requirement. So, for example, an employee suddenly needs surgery. Maybe they didn't provide the proper notice. Maybe they did know about it ahead of time, but didn't give the notice through the right or procedures that you set forth. You may have an argument that, you could deny FMLA leave because they didn't do or didn't give proper notice, but the ADA may still obligate you as an employer to consider the request for time off under the more flexible ADA standards. So another point here that we want to make is that during the leave, you also are allowed to require periodic updates from an employee on their status and on their intent to return. Just make sure that that's consistent with your general policies. And here, let's talk about documentation, because this is where FMLA and ADA leave really differ, and it's crucial to managing both effectively. But the types of documentation required can differ kind of significantly. So with FMLA, you have the notice of eligibility, and this is your first formal communication that you provide to the employee with respect to their FMLA leave. It tells them whether they're eligible for FMLA based on their work history, your employer coverage. This is the starting point for handling those FMLA requests in the FMLA process. You also have your designation notice, which is once the employee is deemed eligible, the next step is to formally approve or deny that request. And this decision-making step is where you outline the specifics of the leave. Then you have your certification of a health provider. And this is the most critical document here because it needs to be completed within 15 days. If employees don't meet this deadline, you can delay or deny the leave, but you really need to have strong communication with your employees and be clear on those timelines on certifications just to make sure that you don't run into hot water here. And then also there's the recertification process. Recertification is allowed under certain circumstances, especially if the need for leave changes. It's good practice to follow up on long-term leave cases periodically. And we'll get more into what kind of communications are allowable or best practice in a bit. And then finally, there's your fitness for duty certification. Before the employee returns to work, you may require a fitness for duty certification just to confirm that they're medically able to resume their job responsibilities. The ADA, on the other hand, may allow more flexibility and more open-ended accommodations. So we can't stress enough that in these ADA cases, it's really about what's reasonable. It's not necessarily about these strict timelines and procedures of the FMLA. And with respect to the ADA documentation, the ADA does not have the same formal notices, eligibility notices that the FMLA does. Instead, the focus is more on documentation of that interactive process that's used to identify a reasonable accommodation. And that documentation is really a critical best practice. You really want to make sure you document any conversations or evaluations regarding their accommodations. And the ADA cases may require more detailed records of the accommodations requested or granted or denied with those explanations. Then also, unlike the FMLA, the ADA doesn't require specific timelines necessarily for submitting medical documentation or certifying health conditions. However, again, it goes back to more what's reasonable. And then with respect to medical information, while not as formal as the FMLA certification process, employers can request documentation of the employee's disability and limitations from a healthcare provider to determine what's reasonable. There's also, we want to make sure here that with the, just the big takeaway here is that the FMLA is structured with more formal timelines and certifications, while the ADA focuses more on flexible, ongoing communication. The key difference is that the ADA really requires less rigid documentation, but more emphasis on the interactive process and individualized accommodations. You're walking a finer line when determining what's reasonable. So we want to make sure that our policies clearly define the processes for both requesting leave under FMLA and requesting accommodations under ADA, just to avoid any missteps, especially when the lines between the FMLA and the ADA can blur.
All right, so we're now going to dive into when and under what circumstances can other types of paid leave be substituted for unpaid leave. So this is a question we get a lot. Is FMLA leave paid? The answer is no, it is always unpaid unless paid leave is substituted. So again, an employee may choose to substitute accrued paid leave to run concurrently with their unpaid FMLA. An employer may require the employee to substitute accrued paid leave to run concurrently with their unpaid FMLA. And again, it's going to take you back to the terms and conditions of your normal leave policies. This is a great time of year. I always mention to take a look at your employee handbooks. If you haven't taken a look at your handbook this year or last year, or maybe the year before, this is a great opportunity to do so. And these leave policies, including your FMLA policy, are great to take a look at. Again, some areas to watch out for here. Disability benefits are not unpaid, but an employer and an employee can agree to have those paid leave, supplement their disability benefits. Likewise, workers' compensation is not unpaid, but again, an employer and employee can agree to supplement. The key here, this is another intersection between the ADA and the FMLA, is the ADA may require unpaid leave beyond the leave allotment under the FMLA. So a common example of this is that an employee is taking leave. They take their full 12 weeks of FMLA leave, but they need an additional 3 or 4 weeks, let's say, to come back to work. And you would need to, just because they've completed their FMLA or used all their FMLA leave allotment, doesn't mean the employer can automatically deny that request. They need to evaluate that request under the ADA to see whether or not any additional unpaid leave would be potentially a reasonable accommodation. So again, just wanted to point some of these issues out for you all. FMLA challenges. So unlike the ADA, where there is an undue hardship defense, meaning the employer doesn't have to provide a reasonable accommodation if it would cause the employer an undue hardship, as that term is defined under the law. However, the FMLA does have a very narrow exception called the key employee exception. We want to note that this key employee exception is rarely used because it is difficult to prove, and proving it, you must be able to provide detailed information. Essentially, what the key employee exception does is it allows a covered employer to deny restoration, meaning putting the employee back in the position that they left at the time they went out on leave, if it would cause basically substantial and grievous economic injury to the employer's operations. A key employee is generally someone who is salaried, FMLA eligible, who's among the highest paid 10% of all employees, both eligible and not eligible at the work site. And so there is no similar key employee provision under the ADA. So again, as you're thinking about the overlap between these two laws, you have to think about each one individually. And even if an employee is denied reinstatement under the key employee rule, that doesn't necessarily mean that they may not be entitled to an accommodation under the ADA if there's no undue hardship to the employer, or if that undue hardship may be mitigated. So thinking about all of these things interacting and overlapping, we wanted to make clear that, as Elysia well mentioned earlier, the FMLA has a sort of specific structure and its own terms that are in some cases very different from the ADA, while the employee's issues may overlap. And so we wanted to kind of cover those. We want to talk now about what type of communications an employer may have with an employee on FMLA. So we mentioned a little bit about this earlier. Again, remember that employees on FMLA leave are not supposed to perform work. So they are meant to be relieved of all of their work duties while on leave. Thus, communications with employees while on FMLA should not be to assign those employees work. A way to sort of manage this or think about it as a practical matter is to minimize your communications with employees while on FMLA leave, as the more communications you have, the more likely or possible it is that a finder of fact could conclude that you're interfering with the employee's FMLA leave usage. Again, this isn't a black and white or hard and fast rule. So this is just some sort of general guidance around how to handle these situations. So we wanted to give you a few more specific examples, which we'll outline on the next slide. So here are some examples of communications that have, been deemed permissible, right? Calls to inform employees of changes in office policies or operations taking place while the employee is on FMLA. Calls to ascertain an employee's anticipated return to work date. Calls to locate missing files, documents, or items, or to obtain information from an employee from FMLA leave. So a court has noted, right, that the FMLA does not create an unfettered right to be left alone. There are still times when the employer may need to contact the employee. We're just looking to minimize those contacts where we can. And again, there's no bright line or hard and fast rule here. So if you need guidance in this area, or if you're unsure, talk to your employment lawyer to get a little bit more comfort about how you're conducting those communications. Now, as Elysia touched on earlier, the ADA really emphasizes and encourages the interactive process between the employer and the employee, which requires that the employer and the employee communicate about any potential accommodations or other issues. So you need to obviously document and think about your documentation around those communications, but there may be, for example, if you have an employee who is returning from leave but may need an accommodation when they return, perhaps they're requesting to work remotely or in a hybrid form for a period of time, then the employer might need to engage in those interactive conversations with an employee who is on FMLA leave before they return. So again, that's another sort of wrinkle where there may be some overlap, and the employer should be, careful in their documentation and guidance about how they're handling those conversations. All right, we wanted to touch on employees with multiple certifications. This can be incredibly difficult for employers to manage, but it is a reality that many employers face. Employees may have more than one certification, and so employers have to identify, what leave is being taken. And if the employee has multiple certifications, they've got to identify which certification applies to potentially which call out or which leave. We recognize that is sometimes can feel like a tracking difficulty for employers, but certainly it's important to track and identify these multiple certifications, which often can happen as a practical matter in the workplace. All right, we're going to move on to disciplining employees on FMLA leave. This is a topic that comes up a lot. So as a general rule here, while the FMLA provides an employee with 12 weeks of job protected leave, and I know you've heard us say that phrase, job protected leave, quite a few times today, it does not insulate an employee from disciplinary actions taken for legitimate business reasons. Okay, employees on FMLA are subject to disciplinary action, just like employees who are not on FMLA leave. However, and this is where, the lawyers usually raise their big red flag signs, right? This is an area where you might want to get some guidance, right? Disciplining an employee while he or she is on FMLA could potentially expose an employer to FMLA retaliation, which Elysia touched on in our earlier presentation. So, it's something to think about. And if you're unsure, it's a place to get some guidance. So moving on to our next slide, if an employer becomes aware of the need to take disciplinary action against an employee while that employee is on FMLA, they may want to consult their labor and employment counsel. That's an area where we'd want, supervisors or managers to also escalate those concerns to HR, and HR may want to escalate those concerns to their labor and employment counsel. It's handled differently at each and every organization, but those are just some areas where you might want to consult your counsel. Sometimes it may be best to allow the employee to exhaust their leave and return to work before you address the issue. There may be other times where that's not the appropriate course of action, and that disciplinary action has got to be addressed promptly, and it's got to be addressed while the employee is on leave. Again, there's no hard and fast exactly when you do this or when you do that. That's why that's an area where you might want to consult and get a little bit of guidance. The long and the short of this is approach these situations cautiously and thoughtfully, and think about your documentation that surrounds them, because it's an area that unfortunately trips a lot of employers up. All right. As we're moving on to our next slide, we're going to look at, thinking about determining disciplinary action that is proportional to the offense. Again, the employee's FMLA leave usage should not be a factor in that determination, right? So again, as we talked about, in either case, you might need to address the disciplinary action while the employee is on leave or after the employee comes back, but whether or not they're on leave shouldn't be a factor in the determination of what disciplinary action is proportional to whatever offense the employee has engaged in. Again, thinking about the ADA and the intersection here with discipline, and if there's some overlap between the employee's need for leave and some protections under the ADA, you want to think about discipline being handled in a non-discriminatory manner. That's whether you're considering an accommodation for an employee or whether you're considering how you apply discipline overall. So, if you're disciplining employees, think about that from a non-discriminatory manner perspective. As you're going forward, again, there's some overlap between these things. And so folks have got to think about more than one issue at once. All right, and we're going to now turn it to returning to work. So Elysia, I'll turn it back to you.
Sure. And I want to be mindful of time, so let me hit the high points here. But when an employee is ready to return from FMLA leave, they must be reinstated to the same or an equivalent position, or I should say generally must be reinstated to the same or equivalent position. An employee should be able to return from FMLA leave to their original schedule and work location with the same or equal in terms of pay, benefits, and working conditions. But I said generally because what happens if circumstances have changed? What if while that employee was out, their entire team was laid off? What if while the employee was out, you changed the shift schedule, or things where the exact or an equivalent position might not necessarily be as neatly determined? So one thing that we really want you to keep in mind is that an employee on FMLA leave is not protected from actions that would have affected him or her if the employee was not on FMLA leave. And here's where things can get a little nuanced. So for example, if a shift has been eliminated or overtime has been decreased for their position or their team, or an employee would not be entitled to return to work that shift or those original overtime hours because, again, the shift's not there anymore. And there's no FMLA protection for job elimination. So if a restructuring resulted in eliminating the employee's position for legitimate business reasons, then the FMLA does not protect that employee from being laid off or not being reinstated. However, the employer as an employee, you really would have to be able to show that that employee would have been laid off during the FMLA period, and that the decision to eliminate their position would have happened unrelated to the employee's leave. Here, I think it's really important that we, again, seek out legal guidance at that point. I think this is a ripe area for litigation where something has happened, circumstances have changed, and the employee is expecting to come back to their exact same job, which under normal circumstances is what you would do. But if for some reason, like I said, schedules have changed, positions have been eliminated, that's where you can get into really thorny situations. And again, as we just previously, or Sarah kind of touched upon, is like, suppose an employee is on leave, shortcomings in their performance are uncovered. FMLA doesn't protect an employee from the consequences of poor performance or misconduct, but it does require you to be cautious. So any performance issues must be addressed in the same manner as if the employee had been working. So because you really want to avoid the appearance of any retaliation for taking leave. Okay, so what do we do when, excuse me, what do we do when an employee comes back but with limitations? I'll take not fit to work a little bit more broadly. If an employee comes back and they can't fully perform their job duties due to a physical or mental condition, like continuing to recover from surgery, or maybe even an injury that's covered by workers' comp, you need to start thinking about the ADA. The FMLA doesn't require you to restore someone to another position if they can't perform the essential functions of their job, but the ADA may require reasonable accommodations. So the first step here would just be determining whether the employee's condition qualifies as a disability under the ADA, which is very broadly defined. And if it does, then that's when that ADA interactive process begins, and you'll need to determine, engaging with that employee, whether you can provide an accommodation for their limitations. So what kind of accommodation are we talking about? These could be things from modifying their work schedule, restructuring their job duties, or even offering additional unpaid leave. You're not necessarily having to offer an indefinite leave, but additional unpaid leave may be an accommodation that is reasonable under the circumstances. The key here is just flexibility and making sure you document everything. So every conversation, every decision that you make sure that you document your rationale, your reasoning for it. And with respect to accommodations that could include additional unpaid leave, we want to avoid the gotcha situations. So for example, imagine an employee comes back from FMLA leave with surgery, but they say they need another month to recover. If their FMLA leave is exhausted, some employers, are maybe tempted to just, terminate them right away. But under the ADA, you may need to give them some more time, assuming it doesn't cause a major disruption to your business. So if they can't handle their full job duties, you may also consider easing them back into the workforce, depending on your company policies or state laws. And also, we want you to keep in mind that other leave policies might apply as well, depending on your company policies or state laws. For example, maybe FMLA was 12-week, but you have additional policies that address a person who was out on maternity leave, for example. You might have policies within your company already to address easing that person back in the workforce that's outside the FMLA and perhaps the ADA. And also, a really big thing here to avoid those gotcha situations is that timing matters. So if there's a critical business need to fill the position immediately, you'll need to document why that's the case and explain why an extended leave or an accommodation would disrupt your operations. That way, again, if the decision's ever questioned, if you unfortunately do find yourself with the claim later on, you'll have a solid business case and really a documented, more defensible business case if you have everything written out, again, clearly explaining the rationale for why you made the decision that you made. So just the big takeaway here, the ADA gives you flexibility. And I'll pass it off to Sarah.
All right, guys, and we know that we have said a lot to you, and including the word document a whole lot today. So we're going to talk about some specific use of certifications and recertifications under the FMLA. Some of you may have heard about second or third opinions. If an employer has received a complete and sufficient certification, but they've got reason to doubt that it's valid, the employer may require that the employee obtain a second opinion. This is at the employer's expense. So the employer can choose the healthcare provider to provide the second opinion, but they can't really select a healthcare provider who they employ on a regular or routine basis. If the first and second opinions reach different conclusions, an employer can get a third opinion Again, this is at the employer's expense. The third healthcare provider must be approved by both the employer and the employee, and that third opinion is final. So again, the employer can think about these second and third opinions, especially as they're thinking about addressing potential leave abuse situations. These second and third opinions are opportunities for employers to address those situations. Recertification from an employee can be requested. It is a complex process, and so we won't have time to unpack every part of it today. But for example, there are certain circumstances like absences that are inconsistent, or if an employer receives information that casts doubt on the validity of the original certification, that an employer can request that an employee recertify his or her serious health condition or the serious health condition of their family member in the same, leave year. And there are, again, some stringent requirements around that and how it is done that are prescribed in the FMLA. So to use Elysia's term, to avoid a gotcha moment, that's one that you want to kind of keep an eye on as you're thinking about preparing your documentation. All right, we're going to move on to another area of leave abuse where we get a lot of questions, which is, does vacationing while on FMLA leave constitute FMLA leave abuse? The answer, most frustratingly to a lot of employers, is not necessarily. Just because an employee is seen doing non-work activities doesn't necessarily mean that it's FMLA abuse. There was actually a recent, fairly recent case that dealt with this issue. It actually resulted in a $2 million jury verdict in favor of an employee who vacationed while they were on FMLA leave. And the court in that case basically explained that in essence, that while just because the employee was on vacation, that doesn't mean that what they were doing was, wrong as a matter of law. Really what the employer should be considering is whether or not the employee's conduct on vacation is consistent with their, stated reasons for leave. And the court sort of observed that an employee recovering from a leg injury may sit with his or her leg raised on the seashore, and they may be fully complying with their FMLA leave requirements. But for example, they may not be able to go and climb a mountain without abusing their FMLA leave process. So that's sort of an extreme example that the court in this case used, but wanted to point out this is an area where employers get a lot of questions. So we wanted to kind of point out this issue for you. The next area that I think causes a lot of questions for employers is intermittent leave. This is a common area for gotcha moments or red flags. Again, the key here is setting expectations with the employee, expectations for how they report absences, how they call in absences, and procedures related to that. Again, this is a great opportunity to look back at your FMLA and other leave policies. This might, for example, discuss the use of, concurrent pay leave, your moonlighting policy, and other things like that. So thinking about how all of your policies, not just your FMLA or your reasonable accommodation, but how all of your policies work together. Discussing planned treatment, medical treatment with an employee. And again, being familiar with your rights as an employer about when you can request that treatment occur around a workday or at a more convenient time. So the long and the short of this is intermittent leave is an area that is often, like multiple certifications, difficult for employers to manage. Ask questions and seek guidance. Again, there could also be overlap with the ADA. So for example, if you have an employee, perhaps that employee is seeking treatment for their personal medical condition. That medical condition may also result in their need for an accommodation at work above and beyond or outside of the leave that they're receiving. Leave may not be the only thing that they need. So thinking through those issues in tandem, and something we've only lightly touched on today, but I'll just mention it as well while we're talking about the interaction of these various laws is workers' compensation. Workers' compensation can also interact with FMLA and ADA issues as well as other leave policies. So again, you might have not one, not two, but three things sort of going on in tandem. So employers just think through those issues. It's an area that can cause some potential concerns. All right, and we'll touch on our last point today. I know we've given you a whole lot of information during this presentation, but just thinking a little bit more about the reasonable accommodation process and how it interacts with the FMLA. Again, the FMLA is specifically a leave statute. It's got rigid time frames. It's got specific definitions that we've covered, specific qualifying events, specific things that are required to that the employer is required to do and that the employee is required to do. The ADA is a little bit more flexible and it focuses more on accommodating disabilities. One of those accommodations can be leave, but it can also, there also are other types of accommodations, maybe remote work, maybe changing an employee's workstation, all sorts of other accommodations. And some of these things might be happening all at once. You might have an employee that needs leave, but then they also need, potentially you're exploring a transfer to a different position, or they've requested to work hybrid for a period of time, or some other things like that. So thinking about how these all interact together, the key for today is reinforcing that your documentation. I think you've heard both Elysia and I say that word lots and lots today during this hour, but your documentation under the FMLA and the ADA is critically important, and being sure that your consistent approach in managing your compliance with both the ADA, the FMLA, and any other state or federal laws that interact with those are critically important. So we wanted to leave just a little bit of time for questions today. We want to thank you all so much for joining us. I know that we packed in a lot of information during this, what feels like an hour that's flown by. So I'll turn it over to Elysia to start with a couple of questions.
Sure. One question that came up was related to an employee seeking to take FMLA leave to care for a parent living overseas, and if there's any special requirements for that certification. And so the answer here, short answer here with looking at time, is yes, an employee can take FMLA leave to care for a parent overseas. There's no requirement that FMLA leave must be taken in the United States. And a certification of a healthcare provider can indeed come from an overseas doctor. The issue there would really be translation into English, and also making sure that you verify the authenticity of the certification. But the mere fact that it does come from a foreign provider does not necessarily invalidate it, or it does not invalidate it just because it comes from a foreign provider. The issue there, again, would be falling back on your employer's right to where you're allowed to ask for clarification, and that includes requesting that the certification perhaps be translated. I would say if that becomes an issue where you are receiving a certification of healthcare provider that isn't in English, I would encourage you to consult legal counsel and to deal with how to, again, get it into a format that you're able to, verify it and make sure that it's authentic.
And I saw a couple of questions in the chat along the same line, which was, what if you discover that the employee is engaged in conduct that would subject them to discipline? Must you wait until FMLA leave has ended to terminate? The answer is, which is the most unsatisfying answer, and I apologize for that, is it depends. The circumstances may dictate a different outcome depending on what the conduct is, when you expect the employee to return to leave, so on and so forth. There are a lot of factors that could dictate that. So the short answer is it depends, and that may be an area where you want to seek a little bit of guidance. Elysia, go ahead. Sorry.
I was just laughing. I know everyone hates that it depends, but it's very, very true. I guess very quickly, one last question was, what happens if you have a temp worker that comes in who replaces that employee temporarily and they're performing better than the employee was? Is that a reason to not bring the employee back? And the short answer is no. You cannot use the temp worker's better performance as a reason to not reinstate that employee. Under the FMLA, an employer is obligated to reinstate the employee returning from leave to the same or equivalent position, and the original employee's FMLA rights would supersede the performance of that temporary replacement. Again, as Sarah was just mentioning, there were some performance issues. There's other ways to address that, but just because the temp was doing better at the job would not on its own be a reason why you would be able to deny reinstatement.
And to piggyback on that question as well, the ADA also, if the employee's out on a reasonable accommodation, may also, require that the employee is reinstated to their position. So even if an employee's FMLA leave is expired, and there may be out on an additional leave under the ADA, you still may have some concerns or some issues to think through in terms of a permanent replacement. So again, kind of one of the overarching themes is just because the FMLA ends doesn't mean that the thought process for the employer ends. They've got to consider the ADA to the extent it's applicable under the circumstances and what impact that may have on a temporary or permanent replacement.
Okay, well, we are at 12:59. I think we're right at time. So thank you all. We had a lot of questions here in the chat, which we just unfortunately aren't able to address. We'll try to reach out to some of you who put some questions there. Again, here's our contact information for me and Sarah. And we are also going to put up the code for those of you that are getting SHRM or HRCI credit.
And we do want to remind you, I saw a lot of questions of this in the chat. A copy of the presentation is going to be distributed, as well as a copy of this recording following the presentation. So please don't worry, you will get a copy of the slides. I know it was a lot of information to cover in an hour, and thank you all again for your time.
Yes, thank you. We appreciate it.
Awesome. Thank you all for joining us today. We will now end the webinar.